to these other witnesses. And the argument seems to be that we are required, when we show a video or document to someone and ask them if they can lay a foundation for it, that we're somehow required to memorialize that in writing and provide a report to the defense. And if we don't, the argument seems to be that's a violation of Rule 16. I would note for the court that we've litigated this issue, and the defendant did not prevail. And I would direct the court to the court's order in D91. So I think D91 covers that situation. And if that objection arises with any of the witnesses I'm going to call, or Mr. Brockler is going to call this afternoon, we are going to be relying upon that. Well, I just wanted to bring that to the court's attention so the court would have an opportunity to review that before it came up.
All right, thank you. I have not sustained any objections that I remember on that basis, and I have not excluded any evidence on that basis. I excluded P-TR-352 because I concluded that Mr. Edson did not establish requirement number 5 of the business records exception under People v. Marciano, and that's that the information was transmitted by a reliable person with knowledge of the event reported. And I also concluded that pursuant to People v. Glover, he failed to establish the additional foundation that's required because the records contained information related to an outside party, including allegedly the defendant and CBI. That case held that you have to establish that there's a business relationship between the company that the witness is a custodian of records for and the outside person or the outside company, and that the company in question, in other words, the company that keeps the records substantially relies for any business purposes on the information contained in those records from those outside sources. And we went through this a few weeks ago, and apparently Mr. Edson either forgot about it already or just missed it. I don't know, but he didn't establish it, so I had to sustain the objection. In terms of P-TR-1100 and P-TR-361, I asked Mr. Edson in about 3 different ways what the probative value was of the evidence. And eventually, I think I understood his position, but in terms of the snap caps, first of all, in terms of the AR mount, he said he would have to talk to his detective first to determine if there was probative value or if it was related to the actual weapons used in this case or the shooting or the items found in the apartment. And what I told Mr. Edson is, you need to know that in advance. You can't be trying to figure out probative value while we're having bench conferences here. In terms of the snap caps, he didn't mention until after I had ruled that apparently they're consistent with some of the weapons that were used in this case. I asked the question about 3 different ways. That didn't come out until after I had ruled. And so, you know, attorneys have a job to do, and I make rulings based on the record and based on the arguments presented. And if the attorneys don't meet the requirements, then you know the evidence doesn't come in. And if the attorneys don't argue the things that are persuasive to me in terms of probative value, then things are not going to come in. So I haven't sustained any objections on the Rule 16 violation. I was entertaining the request to strike part of witness Barbarak's testimony, but Mr. Edson asked for permission to check a report from, I think, Officer Gallegos, and I told him that I would give him that chance, and I think Ms. Higgs wanted a chance to look at that as well, and I told her that I would give her that opportunity. So, frankly, that issue may be moot, given that the surveillance video came in with this witness who's testifying right now, but they asked for permission to look at the report from this agent Gallegos, and I gave them both permission to do that. So I defer ruling on that. All right? So the court will be in recess. Thank you.